Greetings everyone, myself Uthara Nair, an intern at ubAdvocate. So the topic that I've chosen to talk on is the evolution of right to privacy as a fundamental right. So as the topic itself signifies, evolution of right to privacy as a fundamental right, it is evident that right to privacy as a fundamental right was not recognized or was not guaranteed to us from the beginning when the Constitution was made. It was something, or it was a right that was guaranteed or that was recognized as a fundamental right recently, that is through a landmark judgment in the year 2017. So under which article of the Constitution it was recognized as a fundamental right? It was recognized or guaranteed to us as a fundamental right in the Article 21 of our Constitution. So before getting into this evolution, that is the evolution of how right to privacy became a fundamental right and all, it is very important to understand what does Article 21 of a Constitution signifies. So Article 21 of a Constitution states that no person shall be deprived of his life or personal liberty except according to a procedure established by law. Thus, Article 21 secures two rights, that is the right to life and right to personal liberty. And this article comes under Part 3 of our Indian Constitution. Even the Supreme Court called this article as the heart of fundamental rights. The two significant characteristic or feature of Article 21 is that this article cannot be suspended even during an emergency, and the rights that comes in the ambit of Article 21 is guaranteed to all the citizens of India as well as aliens or foreigners. Rights that are included in the ambit of Article 21 includes right to live with human dignity, right to livelihood, right to health, right to shelter, right to speedy trial, right to privacy, and so on. Now coming to my topic, that is the evolution of right to privacy as a fundamental right. So as I said in the beginning, right to privacy was recognized as a fundamental right after a series of judgments, controversial debates and discussions. So the starting point of it, or the starting point where right to privacy as a fundamental right should be given to the citizens or should be given to the people came during a debate in the Constituent Assembly when S. Karumuddin put forth his opinion that right to privacy should be guaranteed or right to privacy should be recognized as a fundamental right. But to this opinion, the makers of a constitution gave only a snobbish support. As a result, it was not incorporated into our constitution. Then in 1954, in an 8-judge bench case, that is the case name is MP Sharma versus Satish Chandra, the issue of the case was that right to privacy should be recognized as a fundamental right. But here again the Supreme Court held that right to privacy cannot be considered as a fundamental right. Then after 10 years in Karak Singh versus State of UP, which was a 6-judge bench, it was held that right to privacy is an essential component of personal liberty, but right to privacy as a fundamental right cannot be incorporated into a constitution. Then after 11 years in the case, that is Gobind versus State of Madhya Pradesh, which was a 3-judge bench, again the issue was put forth, that is right to privacy should be recognized as a fundamental right, but again Gobind lost, that is the court held that it cannot be recognized as a fundamental right. Then on 2017, in the case of Puttuswamy versus Union of India, which was considered as a landmark judgment in the Indian history, right to privacy, the court held that right to privacy should be considered or should be guaranteed and recognized as a fundamental right under Article 21. This right to privacy is not an absolute right. It is subject to reasonable restrictions for the prevention of crime, disorder, or protection of health or protection of rights and freedom of others. Now, right to privacy is an intrinsic part of right to life and personal liberty. So this is about the right to privacy as a fundamental right. So to sum up, as I said throughout this video, right to privacy was not a fundamental right from the beginning. That is, when the constitution was made, right to privacy was not recognized as a fundamental right. But that is in 2017, in the case name called case Puttuswamy versus Union of India, the Supreme Court held that right to privacy should be considered as a fundamental right, as it is an intrinsic part of right to life and personal liberty. Thank you.